Rebel Devs Podcast, a show that challenges conventional thinking in the tech industry. Each episode features conversations with solutionists who have taken unconventional approaches to problem solving, pushing the boundaries of what's possible in their respective fields. Join the Devolution.
Well, hey there, Rebel Devs listener. Welcome to the show. I'm excited for today's show. It's a little different than what we normally do. We typically are Veeam focused and DR focused as well, but today we're going to take a little different slant. We're going to talk to a good friend of ours, Peter Vogel, about some legal matters, which is great. And before I get there, my name is Tom May, your host, and I'm excited to just delve into things a little bit more today. With me, as always, is my partner in crime, Jonah May. Hey, Jonah, what's going on with you?
Well, I am creating registration pages for some bug events we're doing here in about a month.
Oh, there we go. So now when we air this after the event, you all will probably miss it. But the good news is if you missed the June road show, which the Texas bug will be in Austin, Houston, and Dallas, don't worry, he will be hitting the road again in November. So go ahead and check out that website. What is our website over there, Jonah, again?
It is tx.veeamuser.greek.
There we go. All right. And our special guest today, Peter Vogel. I will let the man introduce himself. Peter, good morning.
Yeah, thank you, Tom. Introduction. Thanks for the opportunity to join you and Jonah this morning. Even though I'm a lawyer, in spite of the fact that I'm a lawyer, before I studied law, I had a career as a computer programmer. I have a master's in computer science, worked on a PhD, and then went to law school, but I never intended to be a lawyer. But I've ended up being a lawyer for many years, and my law practice is limited to representing buyers and sellers of information technology and internet services. And I've had cases in 38 states, including all kinds of software development and intellectual property. And then the other half of my practice is transactional, negotiate contracts, including software agreements and things like that. And I'm happy to join the discussion today. So thanks for inviting me.
Oh, absolutely. Love having you here. And Peter and I met probably about the time of my company, Different Dev, being around maybe a year or so. We had some basic legal things in place that got us up and going. And I spoke to a colleague of mine as we were looking at different statements of work, and he introduced me to Peter. And what was really interesting was having a different legal mind that was really wrapped around IT. So in looking for the podcast, sometimes we like to take Veeam a little bit further. And I thought today it would be great to talk about some things that I think many of the listeners deal with. We have end users listening that want to know all things Veeam. Maybe that's not their typical route is dealing with legal, but I'm sure that they have to either provide a service or receive a service. I think that'll hit the marks there. For more of our executive folks, definitely recommend getting in touch with Peter, and we'll get that at the end of the show. It'll be in the show notes as well. But we were going to talk about, the top 10 as a service issues. Peter, you've spoken on this before. Why is this an important topic for us?
Well, I think the reality, Tom, and this is really critical as to where we are in 2025, is every single company, every business around the world relies on cloud computing, except and all cloud computing is based on the contractual terms of and as the privacy policies, and yet virtually nobody ever reads them. I've actually gone around the country over the years and taken a poll about who reads them, and I would say it's about 1% of the people ever take the time to read online terms. So that's why this is so critical, because it affects every business.
Gotcha. Are you kind of referencing like when I get my iPhone and it tells me terms of service? Is that what we're talking about, or is it a little bit mad?
No, that's a good example, but I think the other is maybe even better. And it's what I like to consider, and that is we all give our location away on all our devices. So for instance, one of the things I like to include in a lot of my speeches is a Google map of New York City. When you fly into LaGuardia and then you get in an Uber and the roadway's green, you know it's moving, yellow, not so much. And then if it's red, You don't go that way. Well, where does that information come from? It comes from all the cell phones in all the vehicles on all the roadways because people don't care. But nobody takes the time to read what are the contractual terms they're giving away their location is about. That's why it becomes important.
No,
Be private. Decided that.
a wise man once told me if it's free, you're probably the product. I'm taking it you would subscribe to that thought process.
Something like that. Well, but we live in a time, I think, and I'm glad you use the example of your cell phone because between the Android and the Apple, those products are things that everybody relies on too to help us figure out, navigate from one location to another, and also keeps track of all our phone calls. So from a litigation standpoint, the amount of evidence that we have on our cell devices is crazy. And most people don't care that they give away that right to ownership of the data.
Yeah, no, that's crazy. I myself battled that having a background in IT security was as more and more things went online, as more and more things were tracking. In the beginning, I was so anti everything and I realized I couldn't function. So I kind of had to come up with this personal mindset of how much is acceptable to me. And today's probably the first time that I've done a retrospective myself where I go back and think, well, it's been a slope of giving away more and more and more because now I don't even think about it. And I guess that's partly because, at least in the DR world, we're so tied to security. It used to be prevent the intrusion. And now when we couple in disaster recovery, the number one reason we recover from a disaster is because of a security incident. So we kind of take this thought process of it's not an if, it's a when that the event happens, or we just recover. But now that I think about it, how much am I giving away? While I can recover, is it good that my data is out there? So I'm excited to dive into this a little bit more, for sure.
But it's also, where is your data? I mean, your software as a service agreement, like for instance, there are, and I'm sure there are people on this call that do this very thing. Amazon AWS offers, among other things, Office 365. So instead of having your data go directly through to Microsoft, which you could do, the option is you go through AWS. So then you've got a layer on top of what is your relationship with Microsoft and what rights do you have to get your data in their version of Office 365 versus if you had a direct license with Microsoft. I'm not saying there's a right or wrong. I'm just saying it's more complicated than most people think.
Yeah. And one of the reasons I brought up my cell phone sometimes is it's a hostage situation. I want Google Maps. Well, then I have to succumb to what Google says because I want that. I need that. And yet I've given them a carte blanche to where I almost don't read what it says about Google. If I'm sitting at my desk and I'm going to purchase a service, I'm much more into that agreement, but even still to a limit. Like if I go with an online HR package, and I'm not going to name names because I really don't have an opinion one way or the other. If I decide that that's the right thing for me, if I had software locally and I say, I need this to be a cloud-driven app, well, I need that. I want that. Well, hell, what are they running? I'm just going to basically say, go ahead for it. So this is really just, we haven't even gotten into the top 10 list here, and my brain's already racing in there. Jonah, what are your kind of thoughts on this, if you will?
It sounds like a very nuanced conversation. I don't know. Thankfully, it's a world I've really had to live in.
Well, I mean, you're out there. I'm sure over the years you've used different softwares and in there. And so I almost wonder when it comes to that software, I mean, how do you feel when you're clicking through and whatnot?
I mean, I personally like to self-host where I can. I mean, I know the industry is moving towards SaaS, but in some ways I like to have the own peace of mind that I hold the data. On the other hand, it's kind of nice to know, hey, if something happens, I'm not the one who's responsible necessarily.
Right. Okay. Well, it'll be interesting to get into this top 10 list that we have here. And what I would say is, as we look through, I kind of feel David Letterman-ish, if you will. Some of our listeners may not remember the days, but back, when us dinosaurs roamed the world and we didn't have subscription services, we had David Letterman and his infamous top 10 list. So we're going to dive into that here in just a moment. Well, everybody, it's ready to roll into that fun top 10 list. And when I say fun, it's pretty awesome here. So I'm going to feed up the number one here so I can feel important. And maybe Jonah will bounce back and forth. I'll announce number one. Peter can talk to us about it. We'll chit chat and we'll run through. And so here we go. Number one on the list. And I'll pause here. Peter, are these in any particular order? When you list out number one, are you saying this is the top thing, or are they just kind of all important?
I think they're all important. There's no particular order in which these exist. I just wanted to make sure I captured all the important topics. So thanks for asking. I think that's important.
Great. Yeah, I wanted to have this big dramatic run in, and I thought, well, what if I put the best one out there first? Do we need to go? So without further ado, number one, customer must get a copy of vendors' audit reports from the American Institute of Certified Public Accountants, System and Organizational Controls, or International Standards Organizations. Folks, that's AICPA, which I haven't really touched on, but these other two, SOC and ISO, to verify cybersecurity and National Institute of Standards and Technology NIST certifications. Folks, this is everything we do in DR. I can tell you that. So Peter, tell us, what does this mean?
Well, what happens is people sign software as a service agreements to get software as a service. And that's what the XaaS refers to. It's any kind of services being provided on the cloud. And what happens is you don't always get a copy of that report, but you need to ask for it to find out if this service you're providing is really adequate. Like, for instance, a few years ago, I had a large health hospital that was acquiring a new software system, software as a service. And I said to the assistant general counsel, have you read the SOC 2 Type 2 report? And she said, no, I haven't read it. The InfoSec people have read it and they told me it's okay. And I said, well, you should read the first 26 pages because you will understand that. You're not going to understand anything else, but you'll know that. And it helps you understand what kind of security is in place. Another thing that goes along with that is a few years ago, I was helping a large national company, and they wanted the software as a vendor to provide $5 million worth of cyber insurance. Well, after reading the report, we found out the vendor had $15 million worth of coverage. So we upped it in our agreement, make sure we got all the coverage. So there are things like that you can find in the reports. And if you're doing business with the federal government, they have to use NIST standards. There's also FedRAMP and there's TexRAMP if you're in Texas, where if you're doing business with the state or the federal government, you have to make sure that there's a compliance with all of these SOC 2 Type 2 reports and everything as well.
Some of our vendors, actually have dedicated sales teams to FedRAMP and TexRAMP and whatever state ramp you're in. It just even seems to be a sales specialty in there. I've dealt with companies that are looking to do business, say, with me and SOC, and I always laugh because it's when we're reviewing their vendors, if you will, to choose something, sometimes we'll go ahead and we'll get a SOC certificate, and they'll be like, well, what does this mean? They'll even come to my company and say, do you have a SOC? And in full disclosure, no, I don't have a SOC. My data center is in a data center that has its own SOC and access to customer data. Well, we really don't have customer data in that. Whereas we might use like a ConnectWise or something, which that maintains everything that we have. But, if I'm touching their data, moving their data, it would be of much more concern. So maybe like a cloud provider might be important where they're doing their backups and they're doing recoveries. So interesting that I see people even asking for these and they don't understand the basic premise of what it is and who holds what.
Well, let me also refine that a little bit more. The AICPA SOC report, there are actually 3 different types. There's the type 1, which is done whenever the party wants to do it, the type 2, which is done annually, and the type 3, which is completely useless. because the auditors don't do anything. They just say, this is what the vendor says that they provide, and they just sign off. So if you get a software report, it provides you really no benefit.
Gotcha. Well, I think we're getting ready to move over to number 2 here. So number 2, data locality. Hugely important for us in DR, especially for those of us that are in the MIA and have to deal with GDPR. Peter, definitely speak to this. I'm sure that each state probably has its own data protection rights. I know California was kind of the first out of the gate, but where are we with this concept?
Well, in this context, the bigger issue really is what country it's in, because it's the federal laws of different countries. And it's something that I kind of refer to as internet jurisdiction. And that is, it's the local law, whatever it is, that controls how data is used. And you can negotiate in a software as a service agreement the location of your data. So for instance, in the banking industry in the United States, all data must be stored in the United States. So if you sign an agreement to get software as a service, you need to pay a premium to make sure that data is in the US. If you don't pay that extra premium, the cloud provider can put the data anywhere. And then if you have a problem, you may not be able to get the data because the local laws may cause a problem for you.
Okay. Yeah, no, it makes sense. Jar, do you fall into this kind of trap in your world, if you will, of where's my data and does it matter?
Yeah, very commonly the one we see is Europe. People trying to stay within or Norway or Amsterdam data centers because of GDPR if they're based out of a European country.
It's interesting here because I have some vendors that I've worked with in the past, and let's say in data recovery, let's say they're in Europe and absolutely their data stays in Europe. But let's say this customer creates a monitoring system where they're like, listen, we can hook into your backup system. We can get some report data from you so we can call where your backups are, when the last time they've occurred, and so on and so forth. But our systems reside in the US. Peter, if I'm bound by like a GDPR, I've often thought this was a gray area because the customer saying, no, 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 I don't ever take their data here. Their backups still remain overseas or in that location. I'm just gaining report information and displaying it from a system running in the US. Do you think that's something people need to be concerned with? Is it a gray area, or is that just like hey, this is something absolutely should not be done? I mean, what do you think about those sorts of weird transactions?
Well, I think your characterization gray area is pretty good. It's not black and white, because the laws and the enforcement of GDPR are very different if you are located in the EU than if you're outside of the EU. And that's true with other countries as well. For instance, there are privacy laws and all kinds of things in China that are different. So if your data is in China, it's controlled by Chinese law or Russian law or whatever the law is on where the cloud provider puts the data. And so you have to be mindful of how is it protected. And I think that citizens of the EU do have a concern about making sure that that data is being protected so that they have the GDPR protection that they expect.
Oh, okay. Gray area. That's kind of every time I deal with those EU folks, I'm like, wow, we do feel a lot of gray areas here. So it kind of confirms what I was thinking about. And I know the people often ask me, would you work in this particular zone? And I'm always thinking, well, yes, but there's so many implications over there. I remember I worked for a law firm at one point, and we had offices in Beijing. And I can't get into the specifics all, but even the ability to do business in China required something, if I remember, where like a local company had to be a part of it. There had to be so many local national citizens that would own a portion of that business, and then the outside entity could have a portion of that. So that way it was still, say, a Chinese company or whatnot. And people much smarter than me got into that. That didn't even get into the data things. I mean, pretty much the idea, I think it was anything that is running around in China may or may not have been subject to Chinese listening ins, if you will. I definitely know when I've done business in Moscow, that was a thing. Data had to be stored locally, unencrypted, and then it went off to wherever it needed to go. And the thought process there was, well, that allowed Mother Russia to be able to listen and look at anything they wanted to. I don't know that they specifically came out and said it, but that was kind of the thought process there on it. So definitely think, Jonah, are you ready to tee up into the next bullet point here for us?
Vendor needs to provide details about all AI and generative AI tools used or added to the as a service.
Well, let me say this. I'll say it in the worst way possible. That AI is not new. It's been around for 40 plus years, and there is artificial intelligence software all over the place. But in 2025, what we're seeing is front page news about ChatGPT, Claude, Copilot, whatever the vendor products are. And so what I normally do is when I'm negotiating a cloud software as a service agreement, I always put a requirement that the vendor tell the customer anytime they add a new artificial intelligence tool or identify all the artificial intelligence software that's available or being used by them. They don't always agree to it, but it's a good thing to ask for, I think.
Yeah, I found a project where we were working where AI worked wonderfully to create some reports. So we had some PDF dumps, we had some spreadsheets that come in, and we really needed to kind of compile and cull the data. And really what we were able to do, which was interesting, was we could have fed it all into Chat GPT, which I felt really would have violated our customer. We would have been pumping server names and whatnot in over there. But rather than do that, what I think we ended up doing was we basically took the data that we retrieved, we scrubbed it out and put some sample data in with a smaller subset. We injected it into Chat GPT and we said, based off of this, this, and this, Chat GPT, write me some code to be able to do these things. And we didn't blindly run code. We actually looked through it and brought it local and said, oh, okay, we can see that it's doing this, 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 and this. And then we went ahead with the real documents. We ran it. If it worked or didn't, we went back, reprompted it, generated the code, came back. So in this instance, no customer data was exposed. It was pretty clear, but I don't think a lot of companies are really wrapping their heads around their employees' use of it, how common it is, and what's being up. And I'm hoping more and more companies take the time, like we all have to take basic security awareness training. I think we need to take some AI awareness training in there as well. My wife was telling me that there were rumors at her company that people were doing video interviews and they were running Chat GPT just on the side. And basically Chat GPT was ruining the interview process. And then I read an article today that it's ruining higher education. We finally moved to where remote learning is a thing, where we can do online tests and such. And people are now taking that and they're popping it in through Chat GPT. So Jonah, you have some experience with the whole online learning, more so than I did. When I took it, it was just take the test. But aren't there some safeguards in place when I read an article like that and I read what Peter writes here? Is that something you think higher education is grappling with?
I think it's a struggle for them, especially because it's very hard, I think, for them to figure out when it's AI generated and when it's not for a lot of the content. You have a lot of the typical plagiarism tools, which have updated to reflect whether or not they think a submitted text is AI. But at the same time, a lot of the schools also propose using things like Grammarly and Grammarly AI to help you check all of your papers before you submit them. So if you have it go through and help you with conciseness and grammar and so on, it sometimes ends up sounding like an AI and flagging you as potentially written by an AI.
What a logic loop there, huh? Use AI to help you and then get in trouble for using AI. So, wow, that's kind of such a deep topic. It almost deserves its own little breakout session here. So I'm going to move on to number 4. Vendor must identify all other third-party software as a service products provided and by which companies and on what cloud services all services are provided. That was a mouthful for me, folks. Sorry about that. So is that
I've already talked about that a little bit, and that is, um, if you can go to Amazon Web Services, AWS, and get Office 365, you don't really have a direct relationship with Microsoft. So let's say that you want to get emails that you have from last year. You have to go through Amazon. You're not dealing directly because you don't have a direct relationship with Microsoft. So it's really important that you get an idea about who you are dealing with. Just because you sign contract with one vendor, software as a service vendor, that doesn't mean that's who's providing the service. And I'll give you another example. Amazon also artificial intelligence as a service. You want to use that. And you know who their biggest customer is? LexisNexis. And LexisNexis doesn't say anything on their website about the fact that they're using AWS artificial intelligence as a service. So we have these things where you sign up with one company and indeed you're actually using the software of another one.
I once had a boss, probably 10 years ago now, tell all the engineering staff that one day your engineering skills will not be as valued because you have to transition from being the knowledge expert in all of your areas to being a vendor manager and having a higher level picture. And I don't think many of us believed it at the time, but with what you're describing, I really do see that being a thing where while I might want a LexisNexis because I know what that product is used for, and back in the day, I probably knew how to install it, interface it back to it, use it online, etc. I think what I hear you saying is, well, you have to peek under the hood a little bit more because if I'm using Microsoft 365 on Amazon and I have a problem, well, Microsoft Direct, I go and chat them right in my little console, Microsoft engages and goes. Well, now I have this layering and that really affects my delivery to my customer. Going back to my ITIL days where, I have a service level agreement with my customer, but then I need an operational level agreement with my vendor to make sure I can deliver my SLA. It gets very convoluted if they're kind of hiding some of these things in there. How do I really deliver? Who is my support channel? And that just brings scary to a whole new level for service delivery. So service providers out there, if you're using different products, let's say you're using Veeam Data Cloud, that's one that's all new and emerging here with Veeam. And they tell us, hey, we're going to be the engine. We're going to be the transport. You can be the support. Well, what happens when Veeam Data Cloud goes down? What happens when other things break? And while Veeam, we love them and they tell us 12 nines with this whole Veeam Data Vault, question is when it goes sideways, what is their response to you so you can respond to your customer? And if you're making that cloud to VDC, beyond just the technical ease, I think you need to think about your support structures and response. And that's really my big takeaway in there. All right, Jonah, number 5.
When terminating, the customer should have the ability to decide the format of how its data will be returned and when, and the right to verify data is accurate before the vendor deletes all data.
Yeah, in most software as a service agreements, the vendor includes some kind of provision that says whenever we terminate, we'll just provide you the data in a format we want, that is the vendor wants to put it in, and then within 30 days, they'll delete the data. Well, if for whatever reason, it's in a format that's not helpful to you, you should be able to decide. And I'll tell you, most software as a service vendors are willing to do that, to let the customer decide the format of the data. And then also have a written agreement that the data is accurate, because if it gets deleted before the customer has a chance to validate it, then the data is gone and that customer may be in very bad shape as a result.
Yeah. And I know that we get into the right to be forgotten and those sorts of things. And it was interesting because I remember transitioning through in disaster recovery where none of that was specified in the contract. In the early days, it was just, we protected your data. We put your data somewhere. And when someone went exit, it was almost like a gentleman's agreement of, well, we'll return your data. And sometimes when a customer leaves, they're maybe not in the most pleasant disposition, if you will, and they become quite demanding, knowing that the relationship has soured. And back in those days, it was just, well, you need to be nice to me. I'm trying to help you stop being so demanding. And I'm glad that we're seeing more things in writing with that regard. Number 6 here, I get the easy one, Jonah. Vendor needs to prove compliance with all state, federal, and international privacy laws.
Well, what we see is, first of all, the privacy policies are usually separated from the terms of service, although they're linked together on most websites. And in the United States, the Federal Trade Commission controls privacy. And under their rules, a website does not need to have a privacy policy. But if they have one, it has to be in compliance with the Federal Trade Commission regulations. And so you also then had the California Consumer Privacy Act, and have different states with different laws. And so the privacy obligations of the vendor become very important. But if the vendor doesn't include all of that, then that's a problem. If you ask them to, generally they will, but they ought to be making a warranty that they're in compliance with all the federal and international laws, because you don't want to be in violation of any of those laws by being a customer.
Now that's interesting. So now the compliance of who I'm using affects my compliance. That's just scary.
Now they've got your data. They've got your data. Think about it from a standpoint of healthcare with HIPAA. If they have all your HIPAA data, you've got to be in compliance with the federal laws, and they got it.
Yeah.
Because under the HIPAA laws, if you're the covered entity, the hospital, and they're a business associate because they have access to your data, they've got to be in compliance with those laws.
No, it makes sense. We used to have to do like business agreements with HIPAA companies where it was like, no, I'm not HIPAA certified, but I will promise and solemnly swear that I will follow HIPAA practices such as clean desk policies and whatnot. Because while I'm protecting their data in DR, I'm not really doing anything with it other than storing it and giving it back. So I know HIPAA is famous for having things like clean desk policies. You won't have passwords related and out. Well, I don't really have the customer's passwords, but I still have to swear if I do, I'm not going to write it on a Post-it note and put it on my screen. So that's interesting. 7 here, Jonah, you're going to get, and I think this is like probably the holy grail of this list for our listeners right here.
Yeah, vendor must provide copies of vendor's business continuity plan, incident response plan, successful annual and biannual disaster recovery testing to verify DR works properly, and proof that IRP has been tested, including tabletop scenarios.
Well, one of the realities that I found a few years ago was one of my clients was using a software as a service vendor, and we had a disaster. And the data was not recovered properly. And what we found out was, even though the vendor said in their software as a service online terms that they would do 2 DR tests every year, they had not had a successful DR test in 3 years. So what I routinely do is negotiate contracts and say that the vendor will, and most contracts say that they'll do a DR test like 2 or 3 times a year. And if you want a copy, you have to ask for it. Well, I put a requirement that you don't have to ask when it happens. You ask in advance when you sign up, that every time they have a DR test, they'll provide it to you. And of course, I think, as you pointed out, one of the critical things is that in dealing with business continuity plans and incident response plans, that they need to be tested properly to make sure that we have they're in place.
Well, and I think to our listener, they're normally the ones providing that service. So often I have the onus of the one providing it. So I'm the backup company and I'm going to provide it to my customer. Am I regularly doing the tests so they have compliance? So I imagine a scenario where this customer is providing a service to somebody and says, we do these tests quarterly, let's say. They come into my company and we say, we'll provide it to you quarterly. Do we ever really hand back the results over to say, here they are, this is what they were they good, bad, or ugly? So that way the other customer has compliance. I know many providers in the DR world just go, well, you can have up to so many a year. You just have to ask us to do it. And we're seeing the shift, especially with products like Veeam Recovery Orchestrator or Cloud IBR, where we know that we have to do it. We know that we have to provide it. So you know what? These products add on to the regular DR, and now we can build it and spin it and test it and report it back, and we bring compliance to it. Now we just need human eyes. Was it red, green, or yellow, so to speak? Greens are good. We move on. They have their compliance and it's there. So listeners, again, I think Peter's point here really shows you if you're in the DR world, said it for years, you're only as good as your last test. Make sure that you are providing that over to your customer and giving it to them. My takeaway is I'm not really a DR provider. I'm more of architectural consulting, but I do manage some customers as well, fractionally on their DR team. I put those tools in place and give them to my end customer so they don't have to ask for it. And I think that's what we all need to do is kind of go to that next level. We're just going to give it to the customer. Jonah, you work for a service provider. What do you see as a provider and with your customers?
Muted. I think DR testing is the bane of just about every customer's existence, right? I mean, we have a number of our customers that have the capability of doing biannual DR tests with us, and most don't even use the functionality. I don't know if it's because they're not required to by current compliance and auditors, or if they're just behind on their own things, but there's always a lot of complexity involved. And people even tend to get frustrated when it doesn't go exactly to plan, especially when it's their first few tests, not understanding they don't necessarily want it to go exactly to plan. We want to find the gotchas so that we can plan for them for a real disaster.
Well, I think this ties into our next one here, and I get into this with different dev quite often, is cyber insurance. So number 8 is vendor must provide copies of cyber insurance policies with minimum coverage. So Peter, most contracts, and you hit on this a little bit, say, I will have something in place, and it's a one-liner, and we have a $3 million plan, boom. You're saying provide copies of that. I mean, is that normal that one of your vendors will provide that to them, or do they consider that confidential?
No, most of the software as a service vendors will actually provide copies of all of their insurance. There are some standard forms where they show how much coverage they have and what is included, because as we all know, I think this is one of the problems with insurance. The insurance companies are in the business of not paying claims. I think we all know that. And so what we also need to know is different companies have different types of cyber insurance. Some are included in the CGL, some are errors and omissions, and others are just in what's referred to as cyber insurance. And so you need to make sure that whatever the vendor is providing, that there is cyber coverage. And so if you make a requirement in your agreement, and I didn't say this, but let me just simplify it. A few years ago, I got a Stripe credit card, a purchase agreement. It's long, and I had to look at 37 online terms to figure out what to put in that 6 pages. So most people don't take the time to do that, but most vendors are willing to negotiate the things we're talking about today. And cyber insurance in 2025 is a very common feature that most vendors will provide the details.
No, that's good to know. In my world at Different Dev, I've kind of walked through some clients and we've been in a sales pitch and they'll be like, well, we're the smartest backup people ever. We know Veeam better than you. We know everything in the world. And here you go. Why do we need you? And I point to what you're saying here with cyber insurance and the phrase that you said, they don't like to pay. I mean, they're not in the business of paying. So I'm often like, imagine a world where you do all your smart things, you goof something up, and the cyber carrier goes, well, tough luck. You were supposed to do something. I often say, why not bring in a third party such as myself? Let us go through best practices. Let us drill through it. Let us look at it. And while we may not see an exact copy of your cyber insurance, it will help their positioning and the fact that when it comes to their due diligence, they say, well, we were smart people. We went ahead and tried to do something. And guess what? We even hired this other firm to be able to help us with it. So I think that gives them better positioning because really, I hate to say it, I don't like insurance companies. It's just a battle. And it was easy for them in the beginning to sell cyber insurance. And now I think it's going to happen on such a higher brand scale where it's going to need to be utilized that now they're getting more and more pointed on what brings compliance for payouts. And hey, I know that we're coming to the end of our time here soon. So I'm going to try to turbocharge us here. I'll go with number 9. Jonah, you hit 10, but I'm going to say annual increase of fees should be limited to 3 to 5% or negotiate between vendor and customer. Help me understand that one.
Well, what happens is generally software as a service agreements don't have an annual increase. They just say it will increase. And what I'm saying is when you negotiate your purchase order, that you ought to limit it. But in 3 to 5% range is very common. So you shouldn't let the vendor go too far. But vendors that are unwilling to go to 3 to 5%, you can say, we'll negotiate at the end of the period. The problem, of course, is if the customer gets an increase of more than a reasonable amount, are they going to want to migrate to another software as a service? And there's nothing simple about that because you can't just migrate that easily. And it takes a long time and costs a lot of money. So the migration away is part of the problem.
Yeah, no, I go through that all the time. I think one of my vendors did 6% this year. And I was like, okay, you're pushing it at 6%. And then this was my first year with them and it's become lifeblood to us. I really don't know what we would use with this other alternative because it's so on point. And I started wondering, what's next year going to look like? Or even worse, I'm like, well, what if they said 12%, 25%, 50%? At a certain point, even if you can't replace it, I guess you're just going back to slide rulers or something. But my goodness. Number 10, Jonah.
Vendor must give customer at least 90 days advance notice of changes to all online terms, including privacy policy, and the customer can unilaterally terminate if the new terms are unacceptable with no financial penalty to the customer.
This is something that actually I find vendors are willing to negotiate. The software as a service vendors do this all the time. The problem is, as I just pointed out, is if they change the online terms of privacy policy and you don't like it, and you can terminate, how can anybody migrate away from a software as a service in 90 days? Usually it takes 6 months or a year. And so the vendors, I think that's why the vendors are willing to negotiate this because they don't see that the customer can migrate away very easily. But if there are unreasonable terms that you really don't like, you might want to get away from the vendor. I think, Tom, that was kind of one of the examples you gave before.
No, absolutely. And I mean, so this has been a really great list. I think the listener probably came in and went, oh, law, does this really apply? And I think as we've spoken through, this touches upon all of our lives. You say that we can negotiate. So if I'm going to go with random software person and I need to negotiate something, I mean, besides just talking to you, what would I do to even open a negotiation with one of these companies? I don't know that Apple's going to negotiate with me on the right terms and conditions of the App Store or PeopleSoft for AWS, but you said many are willing to talk. I mean, where would you even go to find out contacts to do something like that?
Well, because most people don't look at the online terms and don't study them at all, or don't look at the privacy policy, my experience has been virtually everyone, including Microsoft, will negotiate if it's something that is reasonable, that they have an unreasonable provision. Like, for instance, I did an agreement for a large international company a few years ago with Amazon, and they gave us, their standard online terms, and I came up with like a 3-page addendum where I changed certain online terms, and they agreed to every single change I had except one, which I thought was really fascinating, and that was they said in their contract that they would send notice under the contract by fax. So I turned to my client. I said, "Do you even have a fax?" And they went, "No." And then what they said was, "Well, Amazon has to have fax." But by the time we got the final version, they deleted fax because it's just impractical. So there are silly things like that where you find it's out of date and it doesn't make any sense because nobody has a fax in 2025.
Yeah, it's funny. When I worked for the law firm, that was one of the things we had to maintain were fax servers. And this was like 2015, 2016. And I was like, good God, we have to have a fax. And it was like, well, certain jurisdictions, you have to be able to take fax to be legally served. So I'm guessing that's going away, which I'm happy because that was like the worst thing ever to go ahead and protect. Peter, I want to thank you for coming on today and just kind of give you some last thoughts. Make your plugs. Guys, if you're out there listening, I've worked with Peter and I know we all get scary about doctor bills and lawyer bills, but I could tell you from my own personal experience with Peter, and I'm definitely not a paid person by Peter to basically busk for him, if you will. But Peter was so on point with our business, reviewing whatever little things we had, rewrote our entire world from terms and conditions to contracts at just an amazing rate. Like, I could not believe his professionalism and delivery. Like, to get the level of resume that we got with Peter and the advice we had was just mind blowing, because I think if I walked into just a general counsel, I would have been lost for hours and cost. And he was just so on point. So I kind of, and talking you up here, Peter, but I think you can say it more poignantly than I can. So please, how do we get in touch with you? And any thoughts here?
Well, I'll tell you, thank you very much for your kind words. And it's, of course, been an honor to represent you and your business. And thank you and Jonah for this discussion today. So to find me, I am on the internet at vogelitlaw.com for information technology. So it's vogelitlaw.com. And I welcome anybody to reach out to me. I'd be happy to take a look. The other place to look is on LinkedIn, which I spend a lot of time there, and I have a lot of contacts on LinkedIn. So that's another place to find me as well, for Peter Vogel on LinkedIn. So thanks for the opportunity to be part of this discussion. I'm glad you found this software as a service discussion of value, and I hope your audience does as well.
No, absolutely. And I hope we can at some point in the future have you back to go over those contracts that you have. You have a top 10 list for contracts. I was browsing through it as well, and I was like, no, actually, that I think is a very on point thing here. Jonah, go ahead, give us your plug, your information and whatnot. Like, tell us.
First off, I gotta say, yeah, all of that's really relevant. This has been beneficial to me, just especially like you mentioned earlier, as we're getting more into the SaaS backup offerings where, maybe myself as a VM service provider is not necessarily self-hosting the backup software anymore and offering a private or hybrid cloud to customers, but rather consuming something like a Veeam data cloud and reselling additional value-added services on top of that. It's all been great to consider. So, you need help. You need a secondary data center to spin up into. You need help with some BCDR. CyberFortress, we're a Platinum BCSP. You can find us at cyberfortress.com.
All right. And I'll play us out. We're differentdev.com to find us. All these contacts are going to be in our show notes. So if you're listening to us, check out rebeldevs.com. The episode's up there with all of our show notes. If you're listening on Spotify or wherever you like, Apple Podcasts, show notes will have all these contacts in for ease. Different Dev, we're going to take care of all of your backup and disaster recovery needs. We're typically not hosting data. We do sometimes, but we're more of just your intelligence, if you will. You probably can't afford a CIO if you're listening to us, or you're a mega shop, like I said, and you have smart people. You need that third-party eye. So we're going to take care of everything related to DR. We're going to do business impact analysis, BCDR. We're going to go ahead and do disaster recovery plans. We're going to audit through and make sure what you think you are doing, you're actually doing, and we're going to keep you advised of the latest trends. So go ahead, reach out to us. And gentlemen, I thank you for joining us today. And everyone else, we'll see you next time we see you.
Thank you.
Whether you're a seasoned solutionist or just starting out, the Rebel Devs podcast is a must listen. So join us. Comment, share, and subscribe. Be part of the Rebel Devs.